Chattel mortgage. It is a conditional sale of personal property as security for payment of a debt or performance of some other obligations specified therein. The condition being that the sale shall be void upon the seller paying to the purchaser a sum of money or doing some other act named. If the condition is performed according to its terms, the mortgage and sale immediately become void and the mortgagee is hereby divested of his title. Characteristics of chattel mortgage. Accessory contract, formal contract, registration is indispensable. Unilateral contract, obligation on the creditor to free the thing mortgaged from the encumbrance. Chattel mortgage, differentiated from pledge. Chattel mortgage, delivery of the personal property is necessary. Pledge, delivery is a requisite. Registration is necessary for validity for chattel mortgage. For pledge, registration is not necessary. For chattel mortgage, procedure for sale is found in Section 14 of Act No. 1508. Pledge, procedure is found in Article 2112 of the Civil Code. Chattel mortgage, if the property is foreclosed, the excess over the amount due goes to the debtor. Pledge, debtor is not entitled to the excess unless otherwise provided, or except in case of a legal pledge. Chattel mortgage, if property is foreclosed and there is deficiency, the creditor is entitled to recover the deficiency from the debtor, except if the mortgage is a security for the purchase of a personal property on installment. Pledge, if the property is sold and there is a deficiency, the creditor is not entitled to recover the deficiency, notwithstanding any stipulation to the contrary. Laws governing chattel mortgage. Chattel mortgage law. Act No. 1508, as amended. Civil Code, Revised Administrative Code, and Revised Penal Code. The Ship Mortgage Decree of 1978, PD No. 1521, governs the mortgage of vessels of domestic ownership. Section 3, Act No. 1508, also known as the Chattel Mortgage Law. The creditor to whom the credit has not been satisfied in due time may proceed before a notary public to sale of the thing pledged. This sale shall be made at the public auction, and with notification to the debtor and the owner of the thing pledged in a proper case, stating the amount for which the public sale is to be held. If at the first auction the thing is not sold, a second one with the same formalities shall be held, and if at the second auction there is no sale either, the creditor may appropriate the thing pledged. In this case, he shall be obliged to give an acquittance for his entire claim. Section 14, Chattel Mortgage Law. Pledges credited by operation of law, such as those referred in Articles 456, 1731, and 1994, are governed by the foregoing articles on the possession, care, and sale of the thing as well as on termination of the pledge. However, after payment of the debt and expenses, the remainder of the price of the sale shall be delivered to the obliger. Article 2121, Civil Code. In a contract of sale of personal property, the price of which is payable in installments, the vendor may exercise any of the following remedies. 1. Exact fulfillment of the obligation should the vendee fail to pay. 2. Cancel the sale should the vendee's failure to pay cover 2 or more installments. 3. Foreclose the chattel mortgage on the thing sold if one has been constituted should the vendee's failure to pay cover 2 or more installments. In this case, he shall have no further action against the purchasers to recover any unpaid balance of the price. Any agreement to the contrary shall be void. Article 1484 of the Civil Code. The sale of the thing pledged shall extinguish the principal obligation, whether or not the proceeds of the sale are equal to the amount of principal obligation, interest, and expenses in proper cases. If the price of the sale is more than that said amount, the debtor shall not be entitled to the excess unless it is otherwise provided. If the price of the sale is less, neither shall the creditor be entitled to recover the deficiency, notwithstanding any stipulation to the contrary. Article 2115 Civil Code. Ownership of the mortgage property. The accessory contract of chattel mortgage has no legal effect whatsoever where the mortgager is not the absolute owner of the property mortgaged. Ownership of a mortgager being an essential requirement of a valid mortgage contract. The manifestations of ownership are control and enjoyment over the thing owned. Union versus Court of Appeals. Offenses involving chattel mortgage. Knowingly removing any personal property mortgage under chattel mortgage to any province or city other than the one in which it was located at the time of the execution of the mortgage without the written consent of the mortgagee. 2. Selling or pledging personal property already mortgaged or any part thereof under the terms of the chattel mortgage law without the consent of the mortgagee, written on the back of the mortgage and duly recorded in the Chattel Mortgage Registry, Article 319, Revised Penal Code. The mortgagor is not relieved from criminal liability even if the mortgage indebtedness is thereafter paid in full or the mortgagor seller informed the purchaser that the thing sold had been mortgaged. The sale is valid although no written consent was obtained from the mortgagee, but the mortgagor lays himself open to criminal prosecution. Subject matter of the chattel mortgage: shares of stocks recorded at the principal office of the business of the corporation and at the residence of the mortgagor. Interest in business. 3. Machinery treated by the parties as personal property. Vessels. It is essentially the mortgage accorded in the office of the Philippine Coast Guard of the port of documentation of the vessels. Motor vehicles recorded with the LTO where the vehicles registered, the place where the property may be found, and the residence of the owner thereof. House of mixed materials. 7. House built on rented land. It does not form part of the land. It is treated merely as an object placed only a land by one who had a temporary right to the same. House of strong materials may be considered as personal property for purposes of executing a chattel mortgage as long as the parties to the contract so agrees that no innocent party will be prejudiced thereby. For purposes of the chattel mortgage law, both growing crops and large cattle are personal property and therefore capable of being mortgaged, although they would be considered as immovable property under certain conditions. Description of the object of chattel mortgage. Section 7 of the Chattel Mortgage Law does not demand a minute and specific description of every chattel mortgage in the deed of mortgage, but it only requires that the description of the mortgage property be such as to enable the parties to the mortgage or any person to identify the same after a reasonable investigation and inquiry. A chattel mortgage shall be deemed to cover only the property described therein and not like or substituted property thereafter acquired by the mortgagor and placed him in the same depository as the property originally mortgaged, anything in the mortgage to the contrary notwithstanding. However, this does not apply to stores open to public for retail business where the goods are constantly sold and substituted with new stock. Chattel mortgage of after acquired obligations. A stipulation in the mortgage extending its scope and effect to after acquired property is valid and binding where the after acquired property is valid and binding where the after acquired property is in renewal of or in substitution for goods on hand when the mortgage was executed or is purchased with proceeds of the sale of such goods. Chattel mortgage of after incurred obligations. A pledge, real estate mortgage, or anticrisis may exceptionally secure after incurred obligations so long as these future debts are accurately described. However, a chattel mortgage can only cover obligations existing at the time the mortgage is constituted. Although a promise expressed in a chattel mortgage to include future debts can be binding that can be compelled upon, the security itself does not come into existence or arise until after a chattel mortgage agreement covering a newly contracted debt is executed either by concluding a fresh chattel mortgage or by amending the old contract conformably with the form prescribed by the chattel mortgage law. If effects of registration creates a real right, adds nothing to mortgage. A chattel mortgage may be alienated or assigned to third persons, but there is no law expressly requiring the recording of the assignment of mortgage. Affidavit of good faith. It is an oath in the contract of chattel mortgage wherein the parties severally swear that the mortgage is made for the purpose of securing the obligations specified in the conditions thereof and for no other purposes, and that the same is just and valid obligations and not entered into for the purpose of fraud. This special affidavit is required only for the purpose of transforming an already valid mortgage into preferred mortgage. The absence of it vitiates a mortgage only as against third persons without notice like creditors and subsequent encumbrances. Right of redemption. When the condition of the chattel mortgage is broken, the following may redeem. A. Mortgager. Redemption from buyer is only the purchase price. B. Personal holding, a subsequent mortgage. C. Subsequent attaching creditor. An attaching creditor whom so redeems shall be subrogated to the rights of the mortgage and entitled to foreclose the mortgage. 3. The redemption is made by paying or delivering to the mortgagee the amount due to such mortgage and the costs and expenses incurred by such breach of condition before the sale thereof. Where a mortgager has breached the chattel mortgage contract, the mortgagee acquires the right to possess the chattel starting from the date of said breach. Northern versus Herrera. Rights acquired by second mortgagee and subsequent purchaser before payment of debt. Number 1. After a chattel mortgage is executed, there remains in the mortgager a mere right of redemption, and only this right passes to the second mortgagee in case of second mortgage, as between the first and second mortgagees. Therefore, the latter can only recover the property from the former by paying him the mortgage debt. After payment of debt. Number 2. If the only leviable or attachable interest of a chattel mortgager is a mortgage property in his right of redemption, it follows that the judgment or attaching creditor who purchased the property at the execution sale could not acquire anything except such right of redemption. He is entitled to actual possession and delivery without first paying the mortgage debt. Rights of mortgagee to possession. 1. When default occurs and the creditor desires to foreclose, the right of the creditor to take the mortgage property is implied from the provision which gives him the right to sell. Number 2. Where the debtor refuses to yield the property, the creditor's remedy is to institute an action, either to effect judicial foreclosure directly or to secure possession as preliminary to the sale contemplated. A. The creditor cannot lawfully take the property by force against the will of the debtor, because the creditor's right of possession is conditioned upon the fact of default, and the existence of this fact may naturally be a controversy. B. Nor can the public officer, such as sheriff, upon whom the law places the responsibility of conducting the sale, seize the property where the creditor could not, as it is manifest that such officer proceeding under the authority of Section 14 of Act No. 1508 becomes the mere agent of the creditor. Buckrock Motors versus Summers. C. It is not required in case of such default that the mortgager refuses upon demand to surrender possession of the mortgage chattel for the mortgagee before he can file an action for replevin or for judicial foreclosure, to first ask the sheriff to foreclose the mortgage or take possession of the property. D. Where the mortgager plainly refuses to deliver the chattel subject to the mortgage upon his failure to pay 2 or more installments, or if he conceals the chattel to a place beyond the reach of the mortgager, it logically follows, as a matter of common sense, that the necessary expenses incurred in the prosecution by the mortgagee of an action for replevin, so that he can regain possession of the chattel, should be borne by the mortgager. Under Section 14, Rule 14 of the Rules of Court, a third-party claimant to a property levied upon by a writ of attachment must make an affidavit showing that he has title thereto or right to the possession thereof. This provision excludes a chattel mortgage because a chattel mortgage is merely a security for a loan and does not transfer title to the property mortgage and to the chattel mortgage. Serra versus Rodriguez. Where the right of the plaintiff to the possession of the specific is so conceded or evident, the action need only be maintained against him who so possesses the property. Neither is a chattel mortgagee entitled to the possession of the property upon the execution of the chattel mortgage, for otherwise the contract become a pledge and cease to be a chattel mortgage. Foreclosure of chattel mortgage. After payment of the debt or the performance of the conditions specified in the chattel mortgage, the mortgagee must discharge the mortgage, otherwise he may be held liable for damages by any person entitled to redeem the mortgage. Public sale. If the mortgager defaults in the payment of the secured debt or otherwise fails to comply with the conditions of the mortgage, The creditor has no right to appropriate to himself the personal property because he is only permitted to recover his credit from the proceeds of the sale of the property at the public auction. Private sale. There is nothing illegal, immoral, or against public order in an agreement for the private sale of personal properties covered by the chattel mortgage. The mortgagor is in estoppel to question it except on the ground of fraud or duress. Period to foreclose mortgage. Chattel mortgage. The mortgagee may, after 30 days from the time of the condition broken, cause the mortgage property to be sold at public auction by a public officer. Real estate mortgage. In case of judicial foreclosure, the grace period for the mortgagor to pay the amount is not less than 90 days but not more than 120 days from the entry of judgment on foreclosure. In default of such payment, the property shall be sold at public auction to satisfy judgment. Civil action to recover credit. The mortgagee is not obligated to file an independent action for the enforcement of his credit. To do otherwise would defeat the purpose of the chattel mortgage, which is to give him preference over the mortgage chattels for the satisfaction of his credit. Northern Motors versus Kokia. A mortgagee who sues and obtains a personal judgment against a mortgagor upon his credit waives thereby his right to enforce the mortgage securing it. Movida versus Rehabilitation Finance Corp. Right of mortgagor to recover deficiency. Where mortgage foreclosed, the creditor may maintain an action for recovery, although the chattel mortgage law is silent on this point. The reason is that a chattel mortgage is only given as security and not the payment of loan in case of non-payment. The action may be brought within 10 years from the time the cause of action accrues. Number 2. Where the mortgage constituted a security for purpose of personal property payable in installments. The vendor of the personal property is precluded from proceeding against the security put up by a third person, for if the latter should be compelled to pay the balance of the purchase price, he will in turn be entitled to recover what he has paid from the debtor vendee. 3. Where the mortgage property is subsequently attached and sold, the chattel mortgagee is entitled to the deficiency judgment in an action for specific performance. Where the mortgage property is specifically attached and sold, the execution of the sale is not a foreclosure sale. Industrial Finance Corp versus Ramirez. Application of proceeds of sale, costs and expenses of keeping sale, payment of obligations secured by the mortgage, claims of person holding subsequent mortgages in their order, and the balance, if any, shall be paid to the mortgagor or person holding under him. Judicial foreclosure of mortgage. File a suit for the purpose. Number 2. Court orders payment for the mortgage debt within a period of not less than 90 days but not more than 120 days from the entry of judgment. 3. If mortgagor fails to pay, the court shall order the sale in public auction. 4. Confirmation of sale. By order of the court which operates to divest the rights of all parties to the action and to vest the rights to the buyer subject to the right of redemption. Before confirmation, the court retains control of the proceeding by exercising sound discretion whether to confirm or not. 6. Execution of judgment. That's number 5. 6. Application of proceeds. And 7. Execution of sheriff certificate. Cases. Union Bank of the Philippines versus Elaine Juniat. GR 171569. August 2011. Facts. Petitioner filed a complaint with prayer for the issuance of ex parte writs of preliminary attachment and replevin against respondent and the third person, non-woban, in possession of the mortgage, motorized sewing machines, and equipment. Petitioner alleged that Juniat executed a chattel mortgage over several motorized sewing machines and other allied equipment to secure their obligation arising from export bills transactions to petitioner. In its answer, Norwovan contends that the chattel mortgage executed in favor of petitioner has no binding effect on non-woven and that it has a better title over the motorized sewing machines and equipment because these were assigned to it by Juniat pursuant to their agreement. Issue whether or not the agreement entered into by Juniat and Norwovan binds third person. Ruling: no. A perusal of the agreement entered into between Juniat and Norwovan early shows that the sewing machines, snap machines, and boilers were pledged to Norwovan by Juniat to guarantee his obligation. However, under Article 20, 96 of the Civil Code, a pledge shall not take effect against third person if a description of the thing pledged and the date of the pledge do not appear in public instrument. Hence, the pledge executed by Juniat in favor of Noruban cannot bind petitioner. Case number 2. Acme Shoe Rubber and Plastic Corporation and Chua Pac versus Honorable Court of Appeals, Bank of the Philippines and Regional Sheriff of Caloocan, GR 103576 Pacs. Petitioner Chua Pac, the President and General Manager of Co-Petitioner Acme, executed a chattel mortgage in favor of private respondent, Producers Bank, as a security for a loan of 3,000. $3 million. A provision in the chattel mortgage agreement was to this effect. In case the mortgagor executes subsequent promissory note or notes, either as a renewal of the former note, as an extension thereof, or as a new loan, or is given any other kind of accommodations, such as overdraft, letters of credit, acceptance and bill of exchange, releases of import shipments on trust receipts, etc., this mortgage shall also stand as security for the payment of the said promissory note or notes and or accommodations without the necessity of executing a new contract, and this mortgage shall have the same force and effect as if the said promissory note or notes and or accommodations were existing on the date thereof. This mortgage shall also stand as security for said obligations and any and all other obligations of the mortgagor to the mortgagee of whatever kind in nature, whatever such obligations have been contracted before, during or after the constitution of this mortgage. In due time, the loan of $3 million was paid. Subsequently, it obtained additional loan totaling to $2.7 million, which was also duly paid. Another loan was again extended, $1 million, covered by 4 promissory notes of $250,000 each, but went unsettled, prompting the bank to apply for an extrajudicial foreclosure with the sheriff. Issue: would it be valid and effective to have a clause in a chattel mortgage that purports to likewise extend its coverage to obligations yet to be contracted or incurred? Hell, no. While a pledge, real estate mortgage, or antichrasis may exceptionally secure after incurred obligations so long as these future debts are accurately described, a chattel mortgage, however, can only cover obligations existing at the time the mortgage is constituted. Although a promise expressed in a chattel mortgage to include debts that are yet to be contracted can be binding commitment that can be compelled upon, the security itself, however, does not come into existence or arise until after a chattel mortgage agreement covering the newly contracted debt is executed, either by concluding a fresh chattel mortgage or by amending the old contract conformably with the form prescribed by the chattel mortgage law. Refusal of the part of the borrower to execute the agreement so as to cover the after incurred obligation can constitute an act of default on the part of the borrower of the financing agreement whereon the promise is written, but of course the remedy of the foreclosure can only cover the debts extant at the time of constitution and during the life of the chattel mortgage sought to be foreclosed. Redad versus Filipinas Investment and Finance Corp. Facts: the spouses Redad purchased from the Supreme Sales Development Corporation 2 brand new Ford Consul sedans, complete with accessories. To secure payment thereof, plaintiff executed on the same date a promissory note covering the purchase price and a deed of chattel mortgage, not only on the 2 vehicles purchased, but also on another car, and their franchise or certificate of public convenience granted by the defunct Public Service Commission for the operation of a taxi fleet with Filipinas Investment. Due to the failure of the plaintiffs to pay their monthly installments as per promissory note, Filipinas Investment foreclosed on the chattel mortgage on the Ford Consul sedans. The foreclosure sale had a deficiency. Consequently, the corporation foreclosed the mortgage constituted on the Chevrolet and their franchise or certificate of public convenience. Issue: whether Filipinas Investment is precluded from foreclosing the second mortgage to recover the deficiency on the first mortgage. Held, no. The vendor of personal property sold on the installment basis is precluded. After foreclosing the chattel mortgage on the thing sold from having a recourse against the additional security put up by the third party to guarantee the purchaser's performance of his obligation, on the theory that to sustain the same would overlook the fact that if the guarantor should be compelled to pay the balance of the purchase price, said guarantor will in turn be entitled to recover what he has paid from the debtor vendee. and ultimately it will be the latter who will be made to bear the payment of the balance of the price, despite the earlier foreclosure of the chattel mortgage given by him, thereby indirectly subverting the protection given the latter. If the vendor under such circumstance is prohibited from having a recourse against the additional security for reasons therein stated, there is no ground why such vendor should likewise be precluded from further extrajudicially foreclosing the additional security put up by the vendees themselves, as in the instant case, it being tantamount to a further action that would violate Article 1484 of the Civil Code, for then is actually no between an additional security put up by the vendee himself and such security put up by a third party insofar as how the burden would ultimately fall on the vendee himself is concerned. Article 1484 of the Civil Code is applicable. Under this article, the vendor of personal property, the purchase price of which is payable in installment, has the right, should the vendee default in the payment of two or more of the agreed installment, to exact fulfillment by the purchaser of the obligation, or to cancel the sale, or to foreclose the mortgage on the purchased personal property if one was constituted. The vendor can only choose one option. If the vendor avails himself of the right to foreclose the mortgage, the law prohibits him from further bringing an action against the vendee for the purpose of recovering whatever balance of the debt secured is not satisfied by the foreclosure sale. Purpose of the law is to prevent mortgagees from seizing the mortgage property, buying it at foreclosure sale for a low price, and bringing suit against the mortgagor for a deficiency judgment. Without the law, the mortgagor buyer would find himself without the property and still owing practically the full amount of his original debt. In this case, defendant Filipinas chose to foreclose the mortgage upon default of plaintiff and brought the vehicles to the public auction as the higher bidder. Filipinas is deemed to have renounced any and all rights which it might otherwise have under the promissory note and the chattel mortgage, as well as the payment of the unpaid balance. The lower court rightly declared the nullity of the chattel mortgage insofar as the taxi franchise and the Chevrolet were concerned under the authority of the ruling in the case of Levy Hermanos versus Pacific Commercial Corporation. The vendor's right to foreclose is limited only to the things sold. The vendor of personal property sold on installment is precluded after foreclosing the chattel mortgage on the things sold from having a recourse against the additional security put up by a third party to guarantee the purchaser's performance of his obligation. Cruz versus Filipinas Investment. Otherwise, if the vendee could still be compelled to pay the balance of the purchase price, the vendee will be made to bear the payment of the balance despite the earlier foreclosure. Judgment appealed from is affirmed. Navarro versus Pineda, GR 18456. Ferfino Pineda and his mother, Juana Gonzalez, borrowed from plaintiff Conrado Navarro the sum of 2,550 and payable in 6 months after date. Pineda executed deed of real estate and chattel mortgages, whereby his mother, by way of real estate mortgage, hypothecated a parcel of land belonging to her. Both mortgages were contained in one instrument, which was registered in both the Office of the Register of Deeds and the Motor Vehicle Office of Tarlac. The defendants failed to pay when the mortgage became due and payable. The plaintiff gave 2 extensions; they still failed to pay. When the plaintiff filed a complaint for foreclosure of the mortgage, defendant questioned the validity of the chattel mortgage over his house on the ground that the house, being an immovable property, could not be the subject of the chattel mortgage. Defendant cited cases to prove their point. Lopez versus Ororza. Issue whether or not the deed of real estate and chattel mortgages is valid or are valid, particularly on the questions of whether or not the residential house subject of the mortgage therein can be considered a chattel and the property of the attorney's fee. Held, yes, the deed of real estate and chattel mortgage is valid. The parties to the contract treated the house in question as personal or movable property. In the deed of chattel mortgage, appellant Rufino Pineda conveyed by way of chattel mortgage my personal properties, a residential house and a truck, and mortgager himself grouped the house with the truck, which is inherently a movable property. The house, which was not even declared for taxation purposes, was small and more made of light construction materials. GI sheets roofing, sawali and wooden walls and wooden posts built on land belonging to another, in cases cited by appellants, are not applicable to the present case. The EA cases refer to the building on a house of strong materials permanently adhered to the land belonging to the owner of the house himself. In the case of Lopez versus Orosa, the subject building was a theater built of materials with more than 62,000 attached permanently to the soil. In these two cases, and in the Long Yi case, supra, third persons assailed the validity of the deed of chattel mortgage. In the present case, it was one of the parties to the contract of mortgages who assailed its validity.